It's 11:40 p.m. Dallas, Texas time. On my blog, which I now have confirmed, my blog has been used in regards to data broker with the U.S. Department of Treasury. On April 4th of 2019, I posted what I had actually done in writing sometime before and asked for an audit. I'm going to read what it says. Either the Texas state auditor, or if there is a conflict of interest, an independent auditor needs to audit any and all agreements for using derivatives engaged by the Texas comptroller for 10 years or 20 if possible, and analyze to see were derivative agreements entered into during that year 5% or less of the approved budget. Were derivative agreements qualified via federal laws applicable to entities qualified via the FDIC, in compliance with then current Federal Reserve policies on use of derivatives, and compliant with federal laws concerning use of intangible personal property and intellectual property rights, and or any laws concerning the use of human beings in processes tested relative to context of agreement as derivatives at the time those agreements were entered into. See, if you're trying to grandfather in a claim off of being able to access a child who is a member, whose father is a member of the military as part of derivatives engaged prior to a war effort, and then you illegally have her declared mentally incapacitated so you could steal her intangible property, and you refuse to acknowledge her efforts at redress while you launder her assets through the State Department, that does not qualify. Continuing on, also identify any lobbyists attempting to influence processes regarding the use of derivatives in preferencing changes to biotech, nanotech, etc. Aspects of small business law retraction. Did governor's purview over that commission violate any federal laws with respect to prior derivative agreements and timeframes? Laws concerning subsidies for the oil and gas industry in regards to green energy or development of affiliated biotech, nanotech sectors? Restrictions, prescriptions on securities law regarding derivative agreements established under Texas laws that may have been used or availed of by the federal government after the respective governor entered into federal position, i.e., Department of Energy. What companies with federal contracts availed themselves of incentives discussed outlined in course of previously outlined investigation? Especially of interest are any oil and gas companies with biotech, nanotech investments that benefited from the governor's commission regarding small business and or applicable terms connected to nonprofits in respective laws and are currently seeking or have been awarded federal contracts via the DOE or DOD, including internationally with special focus on Syria. Cross-reference with HHS investigation concerning frauds against federal trusts and potential collusion with UN, WHO, World Bank. Review codes on auditor's authority to cancel unneeded bonds, as in risks associated with maintaining bonds is not needed. Auditor has authority to call for audit over Texas depositories, which means any bank doing business in Texas and all branches doing business in Texas concerning approved bond issues. Special focus is to be put on bonds approved during the 2017 election, the May 21st, 2018 Dallas-Fort Worth municipal bond, the housing bonds approved for Houston that were outstanding prior to Hurricane Harvey. Auditor also has the authority to call on any securities used by Texas public entities regarding these issues. Also determine were opposing indexes used with respect to specially designated securities bonds, or were derivative agreements manipulated to provide for use as an opposing index in violation of Texas law. This is important for assuring that any collateral used for as inventories is not involved in superseding the 5% requirement regarding use of derivative agreements approved with respect to the state of Texas. So here's the question. Are you floating at least the last 7 days worth of cases before the Texas Supreme Court as a form of opposing index for some other deal? Or in connection with outstanding obligations, meaning that the amount you're trying to secure or you're trying to get away with cannot use any cases that aggregate to more than 5% of the budget. Are you saying that all of the last week's worth of cases is less than 5% of what you need to be floating right now. These are things that would be considered derivatives in accounting for whatever it is you're trying to deal with. How fucking big is this deal? Does this have anything to do with that bond for Dallas that was supposed to settle yesterday? Did you guys get busted actually aiding and abetting the conditions that would actually exacerbate a public health pandemic? And so what? You're not going to be able to get that bond secured unless you negotiate or hustle something real quick tonight? This is treason, guys. This is treason. Right now. This is treason. You went way too fucking far.